Lynn Packer here with OUR Video Op-Ed 17, Utah's Rule of Lawlessness, the Michael Drury Injustice Story, Episode 2. It's a complex story that takes you inside the inner workings of Utah's system of justice, or, better put, system of injustice. It's a story where, for Drury, the rule of law was cast to the wind. This report is mostly about secrecy, about how in 2018 a corrupt Utah Attorney General's office colluded with 2 Utah judges to illegally conduct a secret investigation into Michael Drury and his management of funds for 2 nonprofit organizations. Now, 4 years later, the case exposes the Utah justice system's incompetence, dysfunction, and corruption. It catches Utah's justice system with its pants down, way down. Instead of correcting their mistakes, judges and prosecutors are covering them up. Here's the alleged misconduct that's the topic of this report. 2 Utah judges and an attorney general prosecutor colluded to open a secret investigation under the authority of state law, the Subpoena Powers Act, or called the Act for short. The judge and prosecutor, in concert, violated Utah and U.S. constitutions as well as the Act's requirements. The investigation was based on a falsified probable cause statement submitted to a judge, which the judge was supposed to have reviewed for breadth, relevance, and sufficiency. Judges and prosecutors, in disrespect for the rule of law, worked hand in hand to defy Utah's Subpoena Powers Act and the state and federal constitutions. How far-reaching is the rule of law meltdown? The Utah Attorney General's abuse of secrecy would be bad enough if it were limited to just this one case. But it appears that besides other AG cases, county attorneys throughout the state have been violating the law for hundreds of cases over more than 30 years. Dozens of judges appear to be complicit, shirking their authorization and supervisory duties. If true, it's a colossal breakdown of Utah justice and rule of law. Before I dive into the detail about the Michael Drury secret investigation, I'll provide a 2-part tutorial, beginning with how the law is titled, Subpoena Powers for Aid of Criminal Investigations. It's most often referred to as the Subpoena Powers Act, or the Act for short. Title 77, Chapter 22, Sections 1 through 5 of Utah law begins by explaining the Act's purpose. It's declared as a matter of legislative determination that it is necessary to grant subpoena powers in aid of criminal investigations and to provide a method of keeping information gained from investigations secret, both to protect the innocent and to prevent criminal suspects from having access to information prior to prosecution. The law describes how prosecutors apply to the court for permission to conduct a secret investigation. It says, the prosecutor may, upon application and approval of the district court, and for good cause shown, conduct a criminal investigation. The prosecutor shall, that means must, show that the requested information is reasonably related to the criminal investigation authorized by the court. The prosecutor may, it's optional, make written application showing a reasonable likelihood that publicly releasing information would pose a threat of harm to a person or otherwise impede the investigation. Upon a finding of reasonable likelihood, the court may order the substance of the evidence to be kept secret. Notice that judges are supposed to make findings, which means they must carefully review the applications and explain why they approved. Still quoting from the law, the prosecutor may submit a separate written request that the application, statement of good cause, and the court's order authorizing the investigation be kept secret. The request for secrecy is a public record, placed in the public file, except information that, if disclosed, would pose a substantial risk of harm to a person's safety, a clearly unwarranted invasion of or harm to a person's reputation or privacy, or a serious impediment to the investigation. That means a request for secrecy is always a public record, but the prosecutor may keep certain other information secret. A judge can order even more secrecy, that is, an additional layer of secrecy, if requested. The law says the court may order that the witness not disclose the existence of the investigation to others. The order must be based upon a finding by the court that one or more of the following risks exist. Disclosure by the witness would cause destruction of evidence, would taint the evidence provided by other witnesses. To a target of the investigation would result in flight or other conduct to avoid prosecution, or would damage a person's reputation, or would cause a threat of harm to any person. Note that the judge must make a finding of one or more risks to order the additional secrecy. So, what are findings? They're determinations, usually in writing, of judicial inquiries into matters of fact and law. Findings show how judges applied the facts and law to their decisions. In this case, decisions to authorize secret investigations and subpoenas. Utah appellate courts often refer to findings, such as, the trial court failed to make sufficient findings of fact to support its determinations, or we remand for further findings of fact and conclusions of law, which means findings must be sufficient. The question is, when generally Utah judges order secrecy, do they make sufficient findings? Or any findings at all? We'll see. Continuing with the Subpoena Powers Act requirements, prosecutors shall maintain and file with the district court the following records of the criminal investigation: the good cause statement and application for the authorization of the criminal investigation, all motions made to the court, all court orders, all subpoenas issued, detailed descriptions of all documents and other evidence produced, all transcripts of testimony, all written communications between the court and prosecutors and staff. Spoiler alert, these three requirements are rarely met, as we shall see. Now to the second tutorial, how the Act came about and evolved. It became law in 1971. It was found unconstitutional by a trial judge, but that finding was reversed by the Utah Supreme Court in 1988, but with reservations. It was significantly overhauled by the 1989 Utah legislature with procedural safeguards added, especially greater judicial supervision. It was further defined by case law, appellate court opinions, and it's garnered extensive news coverage over the years. In 1971, Utah Attorney General Vernon Romney, by the way, an attorney general I covered as a reporter for KSL Television, proposed the legislation and lobbied for it. Its purpose, he said, was to combat the continued rapid increase in the incidence of crime in Utah and the growing threat of organized crime within the state. Here's one of lots of news stories about the proposed law. It points out the Attorney General drew it up, and it quotes Alan Meekum, a Republican legislator who took exception to the bill, warning that extended subpoena powers could have grave consequences. You subpoena people, put a hot light on them, make them bring their cars and records downtown before an actual complaint has been filed, and you could have a real problem, he said. Nevertheless, the bill was voted into law. In 1983, the Attorney General used the act to investigate suspected criminal activity involving alleged kickbacks at a Utah power and light company operation in eastern Utah. The investigation led to the filing of criminal charges. The suspects challenged the subpoenas issued to them and their banks during the secret investigation. 7th District Court Judge Boyd Bunnell, a former prosecutor, had authorized the 1983 secret investigation. Bunnell was also the judge who, in 1984, threw out the case, ruling that the act was unconstitutional and was unconstitutionally applied. He ruled it failed to provide for adequate judicial review to protect against abuse of power, was too vague, and failed to protect rights of due process. The Attorney General's appeal to the Supreme Court and that court's review of the matter were widely reported in the press. The attorney for the targets, Don Holbrook, told the Supreme Court justices that the act has given prosecutors statewide unfettered power, and that is not what this society needs. In 1988, the Utah Supreme Court rescued the Subpoena Powers Act and reversed the lower court's decision. It found the act constitutional but unconstitutionally applied and hinted that the legislature needed to fix it, which it did. The next year, the legislature amended the act to specifically include those safeguards. The Senate voted 25-0 to approve, and the House 58-0 in approval. The overhaul included the safeguards that I pointed out earlier in the tutorials, such as prosecutor shall show, the court must make a finding, the court shall narrow, and prosecutors shall maintain records with the court. After the law was beefed up in 1989, subsequent appellate court decisions placed more restrictions on the act. In 1991, in a case related to the UP&L matter, the Supreme Court added another safeguard. The court ruled that notice be given even to targets of secret investigations if their personal bank records are subpoenaed. It's so they have a chance to contest the subpoena. The court's opinion extended the right of privacy to bank records, in that subpoenas for bank records are protected. A bank customer has a privacy right in bank records and has standing to challenge an invalid subpoena. The ruling said, "It is reasonable for our citizens to expect that their bank records will be protected from disclosure because in the course of bank dealings, a depositor reveals many aspects of her personal affairs, opinion, habit, and associations, which provide a current biography of her activities. Such a biography should not be subject to an unreasonable seizure by the state government." Another safeguard was added in 1997 when the Supreme Court decided that, at the very least, a prosecutor's secrecy application needed to be open to the public. In an appeal brought by the Salt Lake Tribune, the court decided that Utah's amended law does not allow the investigative secrecy application to be kept secret. It said the act presumes that the court records generated pursuant to it are open to the public. The code implies that the records are to be open unless the district attorney makes the requisite showing. The Tribune lawyer said, "This means that the state must openly justify closure and give the public a chance to say no to government by secrecy." There it is again. A prosecutor has to show. A judge has to openly justify. Yet another restriction placed on the act came in 1999 when the Utah Supreme Court ruled that once charges are filed, prosecutors can no longer have the court issue secret subpoenas. The decision against the Attorney General was unanimous. The attorney who won the appeal was concerned about the enormous power a special prosecutor or state attorney with subpoena powers can wield. It's a very one-sided street. In this 2006 Supreme Court decision, the justices reiterated their concern about whether a secret investigation could deny a target Fourth Amendment constitutional rights. The court opined the Fourth Amendment provides that the right of the people to be secure against unreasonable searches and seizures shall not be violated. We noted in re criminal investigation that the Fourth Amendment is satisfied if the subpoenaed party is allowed to question the reasonableness of the subpoena before suffering any penalties for refusing to comply with it by raising objections in an action in district court. The decision goes on to say, we did note that to the extent that the concealment of the good cause statement impeded the challenge of subpoenas or interrogations, it operated to deny rights against unreasonable search and seizure. In essence, where no disclosure was made and where all informative documents were kept secret, a witness had no way to challenge a subpoena, thus removing either the lack of disclosure or the secrecy of pertinent documents would ameliorate the Fourth Amendment concern. 3 times over the past 11 years, there have been exposés about Utah judges and prosecutors violating the Subpoena Powers Act. First in 2011, then 2014, and now in 2022, beginning with the report you're watching right now. We'll begin with 2011. It was in 2011 that Utah's justice system got caught red-handed. Instead of using a symbol like pants on fire or Pinocchio, I'll use a pants down graphic to symbolize the expose. In April 2011, the Deseret News ran a story based on a court action I brought against the Attorney General's office for abusing secret subpoena power. The headline read, AG's office accused of abusing investigative powers. And the story said, Packer filed a motion in 3rd District Court last month to require the Attorney General's office to comply with laws regarding the use of investigative subpoenas, unseal documents associated with the investigation, and appoint a special prosecutor to the case. He also lodged a complaint with the Utah Bar Association against the attorneys involved. The story said, Packer then successfully petitioned a 3rd District judge to lift the secrecy order and unseal the case. He said that's when he discovered the Attorney General's office had not filed documents required by the state's investigative subpoena law. My case resulted in a key detailed memorandum decision regarding the Subpoena Powers Act reached by Judge Deno Himonas, who recently retired as a Supreme Court justice. Judge Himonas reasoned that in order to allow courts to review the appropriateness and scope of a secrecy order, the Subpoena Act requires prosecutors like the Attorney General to file various documents with the court, including descriptions of the materials produced pursuant to the subpoenas. Judge Himonas opined further that the materials must be filed in a timely manner, that filing at the conclusion of an investigation is too late. Otherwise, a court could not perform its essential duties. It's apparent that requiring a prosecutor to comply with the Subpoena Act by filing the required documents within a reasonable time would not unduly interfere with the prosecutor's investigation. Still, in 2011, KSL and the Deseret News reported further on the court's obsessive secrecy. The Deseret News wrote, dozens of special criminal investigations tucked away in a locked cabinet and logged in a spiral notebook rarely, if ever, meet the public eye. There is no way for the public to access them or even know they exist. Each one comes with a court-issued secrecy order and the court uses an off-the-grid numbering system to account for them. I'll now play the video of KSL's 3.5-minute story.
Are potentially important government records being kept from the public?
The question arises from a virtually unknown court case, which, as John Daly explains, helped lift the veil on a little-known secret corner of the legal world.
Yeah, Deanie and Bruce, this is pretty interesting. Anyone who wants to find a court case can go online, look it up in the state's court record system. But we found a small group of secret files completely out of public view. We wondered if there was some sort of abuse, would anyone ever know about it? Go to a courthouse and ask for a case file.
Can I have the case file for Michael Anthony Archuleta?
Let's say involving a death row inmate. And you get reams of information.
All right, here you go.
But KSL TV and the Deseret News found there's a category of court case with almost no records.
They keep this so secret that there's just no trace of this on the public record.
Lynn Packer, a trial consultant and former KSL investigative reporter, alerted the Utah Attorney General's office over questions regarding contracting for a software system at Weber State. The Attorney General opened a probe. It got a secrecy order with an investigative subpoena, a secret subpoena issued by a judge. Packer later successfully petitioned a judge to lift the order and unseal the case. He says that's when he discovered the Attorney General's office had not filed documents required by state law.
It's possible for one of these investigative subpoenas to come and go without any trace of it being on the public record.
We asked one court, Salt Lake's 3rd District, to give us any records regarding cases involving investigative subpoenas in the last 3 years.
They gave us 26 files, but the documents contained virtually no information to tell you what the case was about. It did reveal the prosecutor's name, the judge's name, the date, the case number, but besides that, all of the information in these files is entirely generic or it's redacted.
A prosecutor with the Attorney General's office tells us there's a good reason for the secrecy. They don't want to tip off any bad guys.
In my view, absolutely. You just can't go around telling people you're investigating them. It's not very effective.
A criminal defense attorneys group is skeptical.
The more shrouded in secrecy this proceeding is, the more concern I have, and the more concern the public should have.
You've got a balancing of interests here. The government needs some secrecy to conduct investigations, but on the other hand, we don't want to give them a blank check to do whatever they want without any kind of oversight.
We asked for any more information in the files and were told nothing else is public. Where are the files kept?
They're in a locked cabinet.
Brent Johnson, a lawyer for Utah's courts, says the cases on file are not high profile and involve things like tax fraud, sex crime, homicide, and white-collar crime.
You know, obviously I can't talk about specifics.
Still, the court docket for investigative subpoenas isn't exactly inspiring. It's a spiral notebook like you'd use in high school. He concedes there's virtually no way to know much about the cases.
I guess from the public standpoint, it would be difficult to review that, to get information on that.
I completely agree that there are a lot of matters that should be kept secret, but their existence shouldn't be secret.
Now, the main check on prosecutors is judges. We asked several current and retired judges to comment. They all declined. The court says it now plans to look at their handling of the files to see if some of the information now kept in that spiral notebook could be kept in their computer system.
All right, interesting, John. Thanks.
Yeah, you betcha.
The Deseret News added that Scott Reed told reporters that investigators as a group are very eager to go out and investigate. They are less eager to engage in the more mundane tasks of file management and paperwork. The article said secrecy orders do not appear on public court dockets, nor are they entered into the court's computer database. As a result of KSL News and Deseret News questions about how the files are managed, Johnson said the State Administrative Office of the Courts intends to look at how it manages those secret files. Johnson said it will determine if the files can be put into the computer system and what kind of information can be put on the docket. 2 AG officials in particular shrugged off the Act's requirements: Scott Reed and Craig Barlow. Scott Reed, during a 2011 audio-recorded court hearing about Subpoena Powers Act requirements, told the judge that judicial oversight violated separation of powers between the executive and judicial. Reed's point was that it is unconstitutional for a judge in the judicial branch to oversee an attorney general investigation in the executive branch. Craig Barlow, during an audio-recorded 2012 Office of Professional Conduct hearing that centered on the AG's alleged violations of the Act, said no one in his office prepares and files the summaries required by law because he considers it a waste of time and the judges don't want them. 3 years later, after judges were caught shirking their supervision duties, they got caught again. This time I give them 2 pants downs. Here's what happened in 2014. Sean Reyes took over as Utah Attorney General the first month of 2014. He inherited a case that was begun in secret by his predecessors, a case that had all the signs of AG power being heavily abused in connection with the prosecution of business promoter Mark Jensen. I wrote, "It may have been the most brazen practice of Utah's embattled Attorney General's office, the illegal use of investigative subpoenas to conduct secret investigations. Dozens of them, all carried out with surprisingly blatant and admitted disregard for Utah law." I asked Brent Johnson, General Counsel for the Administrative Office of the Courts, to look inside the sealed envelope for the Jensen case to see if all legally required records were in there. Johnson was authorized to look, not the public. He did check while I shot video. And he found no document or evidence descriptions, no testimony transcripts, no indication of any ongoing communications between the court and AG's office, no sign of any oversight. Johnson could not explain why those filings are not there despite being required. "I have no explanation," the court's attorney said. "The law says what it says. I am only reporting facts. But based on those facts, you can see there is a disconnect between what the law says and what I am finding in the files. Maybe someone, the legislature, the courts, or prosecutors will look at changes to see that it's followed," he said. "It's in the statutes for a reason." At that point in time, Sean Reyes was responsible for his office violating the law. I asked him the following questions and got no response. Do you agree with Barlow and Reed's policy of not filing document descriptions and witness summaries during the course of court-authorized secret investigations in order to help facilitate judicial oversight? Do you plan to continue the practice despite the law? Do you agree with Scott Reed that filing those records with the court violates separation of powers? Do you agree with Craig Barlow, who considers it a waste of time? My 2014 report described widespread violations committed by prosecutors and judges around the state as being like a Halloween candy grab. Utah judges hand out secret subpoena power to prosecutors like candy. Prosecutors get the treat. The trick may be on their target's federal and state constitutional rights if judges fail to follow the law that permits them to authorize secret investigations. There has been a change since 2014. Secret investigation files are no longer stored on paper in sealed envelopes. The court was forced to e-file once it ceased paper filing. They are now electronically filed, get conventional case numbers, and are shown on the court's public database, but they're still shrouded in secrecy. The existence of a secret case is now visible online in public view, rather than in a file cabinet out of sight. Reporters, attorneys, and the public can pay a fee, go online, see what's written on the outside of the envelope, so to speak, and a little bit more. The docket shows the existence of underlying documents and indicates whether any are public and can be accessed or private and are secret. The docket indicates the types of documents that have been filed and by their absence, what types have not been filed. But there is still no way to ascertain what each case is about. Now that cases can be tracked online, what can be learned? The number of secret investigations. Hundreds. The number that indicate what the case is about. None. The number of secret investigations that appear to comply with the law. 0. What about transparency? Better or worse? Far worse. The court is in full-on bunker mentality mode. Judges, clerks, and court administrators no longer answer questions about compliance with the Subpoena Powers Act. Then, Brent Johnson, former AOC General Counsel, would answer questions via phone, email, and in person. He promoted transparency. He would look inside sealed envelopes and confirm noncompliance. Now, Keisha Williams, current AOC General Counsel, will not answer questions, whether by phone, email, or in person. She said, "I have advised court employees not to answer questions, yours or anyone else's, that are related in any way to pending or impending litigation." In other words, she issued a gag order. That completes this report's 2 tutorial sections, taking us up to the Attorney General's secret Michael Drury investigation. Episode 1 of this two-parter outlined the state's criminal case against Drury. This second episode now delves into the role the Attorney General's secret investigation played at the outset of the case 4 years ago and still continues to play in 2022. As I reported in the previous video, Drury is a University of Utah Business School graduate, president of United Mergers and Acquisitions, past president, Salt Lake, and Attorney General Honorary Colonels organizations, SLHC and AGHC, former fundraiser and committee member for Utah Attorney General Sean Reyes' political campaigns. Criminal defendant in September 2018 charged with stealing from the SLHC and AGHC organizations and breaching his fiduciary duties to those nonprofits. Criminal charges were brought through Sean Reyes' office in the fall of 2018, and Drury was arrested and jailed for almost 3 months without bail. The Attorney General's office conducted a 7-month investigation into Drury from February 14, 2018 to September 14, 2018. The court, a judge, authorized secrecy pursuant to the act in March 2018. Subpoenas were then issued in secret and recipients ordered to secrecy. Drury never knew he was under investigation, never knew his bank accounts were being seized and searched until well after he was arrested and jailed. Here's how it progressed. On March 8, 2018, Assistant Attorney General Craig Barlow seeks court authorization to conduct a secret investigation. Yes, it's the same Craig Barlow who a decade ago said complying with the act is a waste of his time. The same day, Attorney General Investigator Aaron Jones provides the required probable cause statement. Also the same day, the court assigns the case to Judge Vernice Treese. The next day, Judge Sue Chan reviews the probable cause statement and secrecy request, authorizes a secret investigation, and signs court-ordered secret subpoenas. The day after that, Judge Treese apparently resumes control and supervisory authority over the investigation until it ends September 2018. Why did the court assign the case to one judge, only to have another authorize the secret investigation the next day? It's one of the questions that the court, the AG's office, and the prosecutor will not answer. It's a secret. There's a list of unlawful acts Drury believes prosecutors committed, working hand in hand with the two judges. The Attorney General submitted a deceptive and untruthful probable cause statement to the court when it applied for secret investigation authorization. The court authorized the issuance of secret search warrants without careful review of that good cause statement and without narrowing the search as mandated by law. The AG seized bank records without valid probable cause. The AG seized Drury's personal bank records without giving him prior notice, as required by law. After authorizing the secret investigation and secret subpoenas, the court failed to provide any oversight as required by the Act, to include the failure to put into the record detailed descriptions of all documents and other evidence produced in response to subpoenas and written judge-prosecutor communications. During the secret investigation, the AG made direct contact with Drury to get information without disclosing to him, as required by law, that he was a target of the investigation. I'll go through the list one at a time in more detail to document the breakdown in the rule of law. Some proof of violations can be seen on the court's Drury investigation docket. Even though you can't download the documents themselves, you can tell, at least by the title or each entry, what is there and what should be there. Here's the heading for the Drury case docket. It shows the case number, the name of the assigned judge, Vernice Treese, and the name of the prosecutor who sought the secrecy order. There is no indication that this case involves the Drury investigation. That's secret. Drury only knows it's about him because the state disclosed the case number after he was charged. Even though everything listed on the docket is marked private, that is, secret, some of the violations are easily detected. The application for the secrecy order has to be public. It's not. Drury was supposed to get notice of the subpoena for his personal bank records, another violation. Evidence descriptions, not there. There are no required communications between the prosecutor and judge, another breach. The docket shows the existence of an affidavit good cause statement. It's secret. It's supposed to be the showing made to the reviewing judge that there is sufficient indication that a crime or crimes have been committed. Even though it's secret, Drury obtained what may be a copy among records turned over after he was arrested. This may be the good cause statement filed by Craig Barlow and prepared by his investigator, Aaron Jones. I investigated the AG investigator's 4-page good cause statement. Here are my findings. It's bogus. There is no good cause shown in the document. It's nothing more than a hunch. It's even less than a hunch. It's a mere hope Drury committed a criminal offense. It's wishful thinking. It exhibits an AG's office in desperate search of a crime they can charge Drury with. It lacks any words that would describe any suspected criminal activity. There are no words like theft, steal, embezzle, or breach of fiduciary duty. It uses the term borrow as if that's a crime. The good cause statement's primary accusation is a false claim that Drury used an asset of the SLHC nonprofit to collateralize a personal loan. That is to say, the AG was accusing Drury of committing a crime of collateralizing. The good cause statement describes a scenario where Drury needed to borrow money, say from a bank. The bank demanded collateral, like equity in a house. Drury didn't have any, so he pledges collateral and puts at risk an asset owned by the nonprofit, such as its funds. This note: the SLHC once gave Drury a $100,000 short-term investment loan that carried a higher-than-bank interest rate that was voted on and approved by the board, that was documented in board minutes, that had been paid back prior to charges being filed. And even that loan was not used to collateralize another loan. This next section is about Judge Suchan's failure to properly review that good cause statement before authorizing a secret investigation and secret subpoenas. She made a series of egregious mistakes. Her first mistake was accepting the Attorney General's false claim that Drury used a nonprofit's funds to collateralize a personal loan. Any competent judge or magistrate who gave the good cause statement even a quick read would wonder, why would someone borrow money to collateralize another loan? What bank would accept borrowed money as collateral? A competent judge would have quickly rejected the application for secret bank subpoenas because of the collateral claim not only being undocumented, no witness was quoted, but for also being completely absurd. Okay, here it is. This is from the AG investigator's good cause statement where he accuses Drury of collateralizing. He wrote, "All of the members I spoke to indicated they were concerned by the information they received from Drury regarding the finances of the program. Drury, as a person, acting as a fiduciary for the Salt Lake honorary colonels, acknowledged to program members that he used program funds as collateral for a personal loan other than for whose benefit the funds were entrusted." Okay, so why would the Attorney General's office put that false and ludicrous allegation in its good cause statement? Remember what I said a minute ago, that the AG's office was in search of a crime they could charge Drury with? Here's why the false loan collateral accusation is there. It's to make it look like Drury committed a crime violating a Utah law cited in the good cause statement, Utah Statute 766513. That law has to do with nonprofits and loans, but it's not quoted in the good cause statement. Only the statute title and chapter are referenced. I'll show you in the next slide what the law says. It says, a person acting as a fiduciary is guilty of a violation of this subsection if, without permission of the owner of the property, the person pledges as collateral for a personal loan the property that has been entrusted to the fiduciary. So what the law is saying is that a nonprofit fiduciary, that's an officer or a director, cannot take an asset of the nonprofit, like a piece of real estate, and use that to collateralize a personal loan for the benefit of the fiduciary. In summary, fact, Drury never used any SLHC asset, whether in the form of borrowed or stolen money, to collateralize any loan. Fact, the AG's accusation that he did is false and unproven. It was put in the good cause statement to trick a judge into authorizing secret, illegal fishing expedition subpoenas. Later, the subpoenaed bank records, after those records were illegally obtained, did not show any loan that had been collateralized by an SLHC loan or by any other SLHC asset. Next, Judge Chan's second blunder. The law required that the judge narrow any applications for secret subpoenas as much as reasonably possible to prevent fishing expeditions. A competent judge would have required any subpoena for bank records to be limited to evidence of loans taken out by Drury that were collateralized by a loan or funds of any kind from the SLHC. Judge Chan not only failed to narrow the search, she approved subpoenas for everything in the bank accounts. Here's the search warrant and secrecy order for the nonprofits and Drury's personal bank records. It was signed by Judge Sue Chan. It asks for any and all documentation and or records which you have in your custody or control relating to the Salt Lake honorary colonels and for Michael Scott Drury. Any and all equals everything. It was a massive fishing expedition. The third blunder. Once Judge Chan knew a subpoena included Drury's personal bank records, she should have required that Drury be given notice, as required by law, so he had a chance to oppose the subpoena. That would have given him the chance to prove he did not borrow money to collateralize a loan, or at least a chance to quash the subpoena entirely, or have it narrowed to protect irrelevant personal information from disclosure. Drury received no notice. But, by the way, none was needed for the nonprofit accounts. The fourth blunder. Once the banking records were produced, either Judge Chon or Judge Treese should have wondered where the detailed evidence descriptions were. Had they been produced, one of the judges should have ascertained that the subpoenas did not yield any evidence that supported the good cause statement allegations. There was no evidence of any loan from the SLHC that collateralized another loan. It was a complete abdication of the judge's legally mandated supervisory role over the secret investigation. Now I'll go into material facts that were left out of the good cause statement. Facts the Attorney General was legally required to disclose to help a judge review an application for a secret investigation. It's about the AG's material omissions of fact. Prevailing law, based on the U.S. Supreme Court Franks v. Delaware opinion, holds that a defendant like Drury may seek to invalidate a search warrant for lack of probable cause based on false statements in the supporting affidavit made knowingly and intentionally or with reckless disregard for the truth. The AG's false statement about loan collateral invalidates its secret bank subpoenas. But what about material omissions? Can information left out of a good cause statement nullify it as well? Yes. Utah material omissions law is spelled out in several cases, such as State v. Lee. The court wrote, "The Utah Supreme Court has extended the reasoning in Franks to include misstatements which occur because information is omitted." Goes on to say, "Under Nielsen, a defendant must establish by preponderance of the evidence that material information has been intentionally, knowingly, or recklessly omitted, and that with the omitted information inserted, the affidavit does not support probable cause," which means that material omissions can invalidate a good cause statement, but a defendant, in this case Michael Drury, has to prove that the information was knowingly or recklessly omitted, which Drury can prove. Here are the Attorney General's material omissions. AG investigator Aaron Jones, who signed the good cause statement and attested to its truthfulness, helped set up the Attorney General Honorary Colonels, the very organization he was investigating. Jones, while helping set up the AGHC, made suspected illegal use of restricted government databases to vet honorary colonel applicants. Jones had contact with defendant Drury as the AGHC was being established, before Jones investigated Drury. Other Utah AG staff members were helping set up the AGHC to include how its funds were used. Some AG employees may have done work on the nonprofit during government-paid time. Drury had served on several Sean Reyes campaign committees and hosted fundraisers prior to the secret investigation. The fundraisers involved the Salt Lake Honorary Colonels, whose money the AG falsely accused Drury of borrowing or stealing. Some of the money the AG alleged Drury borrowed or stole ended up in Sean Reyes's campaign coffers. Question: are those material facts a judge should know before authorizing and supervising an AG secret investigation into Drury and into an organization the AG helped establish? And I'm not even finished listing material omissions, like one involving selective prosecution. The AG's probable cause statement omits the material fact that Attorney General Reyes has not brought a breach of fiduciary duty criminal case against any other nonprofit officer or director. That's despite the fact there are hundreds of Utah nonprofits with officers and directors who have fiduciary obligations. That's despite the fact that Reyes himself believes there are lots of Utah nonprofits committing fraud. How do we know that? In late 2015, Attorney General Sean Reyes participated in a fundraiser at Davis High School in Kaysville on behalf of the nonprofit Operation Underground Railroad. Reyes vouched for the charity's integrity, saying, I've sat on maybe over a dozen nonprofit boards during my career, and I know there is a lot of corruption, a lot of fraud, and a lot of ego in the nonprofit world. About OUR, whose board he sat on while Attorney General, Reyes said, "I saw none of that, and I really looked hard at Operation Underground Railroad." This note, OUR is now under criminal investigation by the FBI and Davis County Attorney's Office. There's another nonprofit example, Reyes' support for former President Donald Trump. Trump's nonprofit wrongdoing is established as fact, yet that did not alter Reyes' Trump support. Proven. Trump Foundation's breach of fiduciary duty, improper self-dealing, and misuse of assets. New York's Attorney General, our petition detailed a shocking pattern of illegality involving the Trump Foundation, including unlawful coordination with the Trump presidential campaign, repeated and willful self-dealing, and much more. So it's okay with Reyes if Trump has proven nonprofit violations, but not okay if Drury has unproven nonprofit violations. Pivoting now to questions about how judges have been assigned to the Drury criminal case, and why court administrators are keeping details about that process secret. Judges Chon and Treese were engaged at the beginning of the case, then two judges took over in the middle, and now both Chon and Treese are re-engaged. After the secret investigation ended on September 14, 2018, Drury was charged in the case assigned to Judge Royal Hanson. Last year, Judge Hanson retired, and the case was assigned to Judge Amy Oliver, but only for 4 months. Her short-term assignment was odd and unexplained. Drury knew a change of judges was coming, so he delayed and filed a motion with Judge Oliver to disqualify the state's two key witnesses. The motion was unopposed by the state and ready for a ruling. Nothing happened. Judge Oliver refused to act. Drury was told, without explanation, that the case was going to be transferred yet again on January 1, 2022, to Judge Sue Chon, the same judge who authorized a secret investigation 3.5 years earlier. It was bizarre. Nothing had happened for 4 months, then the case was transferred to the judge Drury believes botched the secret investigation. Here's how it went. Judge Treese was first assigned the case. Then it went to Judge Chon, who authorized the secret investigation. Then it went back to Judge Treese to supervise the secret investigation. Then the criminal case was assigned to Judge Hanson. He retired. Then it went to Judge Oliver, who sat on it for 4 months, doing nothing. Then back to Judge Treese to handle a motion to lift a secrecy order that another judge, Chon, had authorized. And the main case went back to Judge Chon. It was a case that Judge Chon had requested to get back via a bid process. As the flowchart showed, Judges Treese and Chon engaged, disengaged, then re-engaged. Judge Treese was assigned the secret investigation in March 2018, somehow deferred to Judge Chon to approve the secret investigation. Why? The court won't say. It's secret. She is now deciding whether to lift Judge Chon's secrecy orders, which could reveal that she failed to supervise that investigation. It's unexplained why Judge Chon was assigned to approve the AG's application for a secret investigation and for court-issued subpoenas. That's secret. She had oversight duties, but relinquished those to Judge Treese. Exactly when, why, and how? That's secret. With Judge Hanson's retirement, she bid to get back the case she began. She's now reviewing motions that contest the validity of her authorization for the secret investigation. The Drury matter has exposed yet another corrupt 3rd District Court practice. Judges being able to bid to get cases they want to oversee. The court's bid process amounts to judge shopping, not lawyers shopping for judges, but judges shopping for cases. On January 3rd this year, the Drury case was assigned to Judge Sue Chan. The assignment was not random, but by what court clerks call a bid process, wherein Judge Chan and other judges bid on the cases abandoned by the retiring Judge Hanson. Presiding Judge Mark Corus awarded the Drury case, with others, to Judge Chan. Clerk of Court Chris Davey said the bid system has existed for years, but there's nothing in writing that delineates the process. Through the court's bid process, Judge Chan regained authority over the matter she initiated in 2018 and failed to supervise. AOC General Counsel Keisha Williams denies judges can request cases. After I asked her about the court's bid process, she emailed a reply. It said, "No, the 3rd District Court does not assign cases via bidding process. Cases are assigned randomly." She wrote, "I believe the misunderstanding is related to the difference between case assignments and calendar assignments. To use your example, when a judge retires from the 3rd District bench, the entire calendar they presided over, that is civil or criminal, is open to fill." But then she goes on to describe a bid, not random process. Judges in the 3rd District will notify the presiding judge that they're interested in, let's say, a vacant criminal calendar. If 3 judges express an interest in taking over the vacant criminal calendar, the presiding judge assigns the calendar to the most senior judge from among those who expressed an interest. Here are Michael Drury's objections to Judge Chan's assignment. How she got the case. At her initiative. Judges bidding to get cases is extraordinarily unethical. Until now, the court has kept the bidding practice secret. Conflict of interest. At present, she's dealing with a Drury motion which questions her approval and supervision of the secret investigation she authorized. She did not recuse herself from hearing a motion about her conduct. Her extremely poor performance rating as a judge. Utah's Judicial Performance Evaluation Commission recommended she not be retained as a judge. When Chan was first nominated in 2012, the Utah Senate Confirmation Committee voted 4-2 against her confirmation. The full Senate approved her nomination anyway. When she was up for voter approval in 2016, the Utah Judicial Performance Evaluation Commission voted 7-2 against her being retained. She won at the ballot box anyway. The Drury matter shows that now, in 2022, the Utah court system's abuse of the secret Subpoena Powers Act is worse than ever, earning a whole slew of pants downs. In 1988, Utah Supreme Court Justice Daniel Stewart, who died in 2005, cast the lone dissenting vote when the court upheld the constitutionality of Utah's Subpoena Powers Act. Justice Stewart wrote, "I believe the Subpoena Powers Act is unconstitutional on its face. The act vastly extends the compulsory inquisitorial power of state and county prosecutors over both citizens and government officials. Unfortunately, our history is fraught with examples of abuses of such inquisitorial powers by government officials." Justice Stewart was worried the Attorney General's office could use the powers conferred by the act to rummage through the affairs of political enemies to harass and embarrass them on the flimsiest of pretexts. In 2018, a corrupted Attorney General's office went after Michael Drury, who had become a political liability. The AG's prosecutor began a secret investigation in violation of state and federal constitutions, as well as violating Utah's Subpoena Powers Act. Prosecutors around the state appear to be doing the same. And even worse than what Justice Stewart feared, Utah judges are complicit. That's the end. Thanks for watching.